welcome to the Tax Court of Canada. My name is Susan Wong. I'm a justice with the court, and along with my colleagues, we hope to provide you with some useful information to help you prepare for your day in court. Preparing for court can be an intimidating task, especially if you're representing yourself. We hope that this video will give you some useful information and help you understand what's expected of you. Please don't use this video as a substitute for legal advice, for the court's rules, or for the law. It's important to use each resource in the way that it was meant to be used. In this video, we'll cover what to do before the hearing, what to expect on the day of hearing, and what happens after the court gives its decision. You'll also see scenes from a fictional day in court, which will hopefully help you picture how it goes. Generally, the way you end up before the tax court begins with you filing your tax return. The Canada Revenue Agency eventually sends you a notice of assessment, and if you disagree with it, you file an objection with CRA. CRA reviews your assessment, and if you still disagree with their decision, you appeal to this court. In this video, you'll sometimes hear me refer to the Minister of National Revenue because under the law, it's the Minister, not CRA, who's actually considered to make these assessment decisions. After you file your notice of appeal to this court, the Minister will file a document called a reply. Normally, the next step is for you to receive a hearing date from the court. However, sometimes there are other steps that might need to happen first. It just depends on the circumstances of your particular case. When your hearing is scheduled, you'll receive either a document called a notice of hearing or an order. Regardless of which document you receive, mark your calendar. Court time is precious and limited. If you're not available on the assigned date, or if you later become unavailable, you should send a letter to the court as soon as possible explaining in detail why you can't attend and asking the court to reschedule. This is called an adjournment request, and it's important to know that even if you ask for an adjournment, the court might not grant it. If you don't attend your hearing and the court did not grant you an adjournment, your appeal might be dismissed for failure to appear. The tax court sits across Canada, so be sure to check your notice of hearing or order for the exact time, date, and location of your appeal. Being prepared and organized will go a long way to helping your court day go as smoothly as possible. For example, it's a good idea to write out an outline of your oral testimony ahead of time. Your oral testimony is what you'll be saying when you're in the witness box. If you plan to have other witnesses testify as well, then you should think about writing to the court registry and asking for subpoenas, especially if you need professionals such as doctors or accountants. A subpoena is a legal document that compels a witness to come to your hearing and to bring any documents specified by you. Under the tax court's rules, if you serve a witness with a subpoena, you have to also at the same time include a standard witness fee, plus enough money to cover that person's transportation, accommodation, and meals while they're attending your hearing. You should also consider meeting with your witnesses before the hearing to explain why you need them to testify. If you or any of your witnesses needs a language interpreter or has other special requirements, you should inform the court registry in writing as soon as possible so that arrangements can be made. The court needs at least 2 weeks' notice to try to make these arrangements, and there's no charge for these additional services. You're expected to be ready to start on time on your hearing day, so there are several things you should do in order to be as ready as possible. First, you should think about what the issues are and what you have to support your position on each issue. Second, you should gather all the documents that relate to each of the issues. Get familiar with your documents and organize them in the order that you want to present them. You should have at least 5 copies of each document for the court. One for yourself, one for the judge, one for the registrar, one for the Crown, and one for the witness. In some appeals, there's an additional party called an intervener, so you would need a total of 6 copies of each document. That doesn't happen often. Lastly, it's a good idea to observe a hearing beforehand if you can. It can be very helpful to see the things I'm talking about being carried out in a real-life situation. To see what's coming up on the court's calendar, check our website or contact your nearest tax court registry for this information. You should arrive and be ready at least half an hour before the time on your notice of hearing or order. Before you're allowed in the courtroom, you'll need to go through security screening. Some items are not permitted in the courtroom, and cell phones should always be in silent mode. You also can't record videos or take photos in the courtroom. As far as what you'd wear, I'd recommend that you dress the way you would dress for a business meeting. In other words, you may not have a suit to wear, but your clothes should not be casual either. When you enter the courtroom and before court has begun, you should go to the registrar and let them know you're there. The registrar will be sitting at the front of the room near the judge's bench. They might tell you where you should sit and have other general instructions for you. They might also be able to answer any general questions you might have, but they can't discuss anything legal with you. In a typical hearing, you will see the following people: the judge, who controls the proceeding and makes the decision at the end; the registrar, who records the proceeding, administers oaths, keeps track of exhibits, and basically directs any traffic that's not directed by the judge; witnesses, you, the appellant; a lawyer from the Department of Justice who represents the minister as the respondent; members of the public, as most court hearings are open to them. If a language interpreter is needed by anyone, you would see that person too. During your hearing, you would sit at a designated table except when you're testifying. The Crown Counsel will also be sitting at another designated table. The judge sits up on the bench, the registrar sits in front of them, and everyone else generally sits in the gallery. These locations will be fairly obvious when you see the room. When the judge enters the room, court is in session and everything is recorded. You should stand when the judge enters the room and whenever the judge speaks to you. You refer to the judge as Your Honor and the registrar as Mr. or Ms. Registrar. After the judge enters the courtroom, the registrar will call your case name and file number. The judge might make some introductory remarks, and then you would start presenting your case. Before we discuss your actual presentation, let's talk about what you should keep in mind while you present your case. To do that, you should look at the minister's reply to your notice of appeal. There's a section in that document which talks about things the minister assumed to be true when you were assessed. The law says these assumptions are true unless you, the appellant, can successfully challenge them, which is also called rebutting or demolishing the assumptions. That is why you testify, bring documents to court, and maybe other witnesses as well. The minister expects taxpayers to challenge these assumptions in tax court, so they might also bring witnesses and documents. The judge has to decide whether each fact is true based on a balance of probabilities. In other words, is it more likely than not that something is true? All right, so now let's go back to your actual presentation of your case. When you're representing yourself, you will almost always have to testify as part of your case. To testify, you would take your documents and change locations to the witness box. You'll be asked by the registrar to give a promise to tell the truth. It can be an oath, which is faith-based, or it can be an affirmation, which is non-denominational. It's your choice. You then start giving the court your evidence by testifying, which is called oral evidence. While you're testifying, you should present any documents you would like the court to see as you go. These documents are the multiple copies I mentioned earlier that you should have. These documents are called exhibits, and as you present them, the court will give them names and numbers so that we can keep track of them. Sometimes the lawyer for the minister might stand up and say that they object to a certain document becoming an exhibit. The judge will have to make a decision about whether that document is an exhibit before moving on. When you're testifying, you should try to be as logical and chronological as possible. The judge doesn't know anything other than what's in your notice of appeal and the minister's reply, so your narrative should be as easy to follow as possible. The other thing to remember is that when you're testifying, you should focus on what happened. After all witnesses have testified, you'll have a chance to tie everything together and tell the court why they should agree with you. When you finish telling the court what happened, the Crown Counsel will have a chance to ask you questions. This is called cross-examination. At any point while you're testifying, the judge might also have questions for you. After the Crown Counsel and the judge have asked their questions, your testimony is over and you can return to your designated table. If you have other witnesses, we would repeat the same process with each witness. Each time the Crown finishes cross-examining a witness, you will have a chance to ask follow-up questions, which is called redirect. After all of your witnesses have testified, your case is closed, and it's the Crown's turn to present the respondent's case. Sometimes the Crown will have witnesses and documents of their own, and other times they will rely on their cross-examination of your witnesses. The same questioning process happens in reverse with the Crown's witnesses. They testify, you cross-examine, and the Crown can redirect. When all of the Crown's witnesses have testified, the respondent's case is closed. Before I move on, I should mention another type of evidence called affidavits. These are written statements made by someone who takes an affirmation or oath that their written statement is true. The law allows the minister to use affidavits for specific purposes, but otherwise we rarely accept them in our court. When both sides' cases have closed, the next step is closing argument. It is the time for you to tie together what the judge has heard from the witnesses and explain why the judge should agree with you. This is also the time for you to refer the judge to any court cases you think are important to be aware of. You should bring at least 3 copies of any court case, one for you, the respondent's lawyer, and one for the judge. The Crown will do the same. Normally, self-represented people have a choice to argue first or to hear the Crown argue first and then go second. Whoever goes first goes last, because they will have a chance to reply to what they heard. After the arguments are done, the judge will make a decision which can be oral or written and can be on the same day or in the future, especially if they need a bit of time to think about what they just heard. If the decision is in writing, it will be posted to the tax court's website and might be picked up by other publications as well. All decisions are public information, but the written ones tend to be easier to locate than the oral ones. Our court is an independent and impartial court and has no connection to the Department of Justice or the Minister of National Revenue, but nor do we work for you. My fellow judges and I do our best to be fair at all times. We try to balance the fact that you're representing yourself with the expectation that you be prepared to do that. If you disagree with the tax court's decision, you have 30 days to appeal it to the Federal Court of Appeal. Information on how to do that can be found on their website. This concludes our video. We hope it helps you prepare for your day in court. Please remember that adequate preparation plus understanding the process are essential when representing yourself. For more information, you can browse the various sections of our website. The registry is also available to help you if you have questions. Thank you very much for watching.